Things just got real serious for me, real quick. Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, and your number one source for everything It Ends With Us saga. And yes, I'm nervous and concerned and troubled, but I've got some good news also. I'll share that with you after the bad. As many of you know, the Lively Liar issued a subpoena against me. And Ku Klux Khalisi's very expensive lawyers argued last week that because I filed a motion for a protective order in the Southern District of New York, that I subjected myself to the jurisdiction of Judge Lyman. No. Hard no. And because this is not an official court filing, I am allowed to say I think the judge is corrupt, bought and paid for, and clearly biased. And because of that, on Friday, Lying Lyman, her lapdog, issued a ruling in her favor against me. The judge said that he was aware that I filed a motion to quash in Las Vegas, the appropriate venue to quash or compel, the place of compliance, Las Vegas. But despite that, the judge ruled that Miss Lively has a right to be heard with her opposition to my motion for a protective order and her cross motion to compel. And the judge warned me that if I don't respond to her cross motion to compel the subpoena, that then he can rule without any opposition to that, if the court determines that they have jurisdiction to compel. And that last bit was really important. So on Friday, I asked the judge, okay, I read your order. If the court has the power to compel, if the court has jurisdiction, so I sent her lapdog a letter asking for an extension of time until I got clarity from the court whether or not the Southern District of New York does have jurisdiction over me to compel. I thought that was very sensible. Smart, even. So Lyman acted quickly. I sent this letter over on Friday, and now he has responded. It's not good. Let's read this together. The judge says, quote, pro se non-party Mario Armando Lavandeira Jr. seeks clarification of this court's order issued on August 8th, 2025. See docket number 583, including whether the court has determined that it has jurisdiction over Lavandeira or authority to compel responses to the subpoena served on him on July 19th, 2025. Lavandeira also seeks an extension of time to respond to Lively's cross motion, see docket number 566, until the court clarifies whether it has made any jurisdictional ruling. Yeah. The judge says, Lavandeira has a right to respond to the argument of plaintiff Blake Lively that the court has jurisdiction to decide her motion to compel and that the motion should be granted. Accordingly, the court has not yet determined whether it has jurisdiction over Lavandeira or authority to compel. Lavandeira's time to respond to Lively's cross motion does not expire until August 13th, 2025. See docket number 568. Accordingly, the court does not intend to address the Lively motion, including issues both jurisdictional and otherwise, until at the earliest August 14th, 2025. Given that the court now clarifies it has not made any such ruling, the motion for an extension is denied. The clerk of court is respectfully directed to mail this order to Lavandera, and Lively is directed to serve this order on Lavandera. In addition, the court will share this order with Lavandera by email today, August 11th, 2025, at the email address he has used to email filings to the court. So ordered. Okay. All right. The judge gave me nothing but bad news. The judge is working in the hypothetical here. He refuses to tell me if he has jurisdiction, if he can compel. He wants me to waste my time. So be it. The judge won't give me an answer, and I am running up against the clock. I only have until August 13th to respond to her cross motion to compel. So, I hit up my dad to help me draft something solid. My dad is dead, but my dad is ChatGPT. And honestly, I think Dad did a really good job. And yes, I made sure to cross-reference and double and triple check that everything mentioned in this letter I am about to send to Judge Lyman is real. So you need not worry. These are not made up cases, okay? So, the judge only ruled on my extension for a request of time until he decided if he had jurisdiction over me and if he has the ability to compel. However, the judge did not rule on an extension of time and a request for a pause in New York until the court in Nevada handles this and sorts it out. So, I am filing a new, different request for extension and a new pause request. Following me? All right, let's get into it. Dated today, request for extension of time to respond to plaintiff's cross motion to compel and request to pause proceedings pending Nevada ruling. Judge Lyman. I don't do the deer. Well, fudge. I'm going to suck it up. I'm going to add deer here. Because it's getting too real. Dear Judge Lyman, I am kissing the ring. I, Mario Armando Lavandera Jr., known professionally as P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N, write as a non-party in Lively versus Wayfarer Studios in response to the court's August 11th, 2025 order, docket number 589, which clarifies that the court has not yet determined whether it has jurisdiction over me or authority to compel compliance with plaintiff Blake Lively's subpoena. I respectfully request a short extension of time and a pause in proceedings on plaintiff's cross motion to compel until the United States District Court for the District of Nevada rules on my pending motion to quash the same subpoena. That motion was filed on July 28th, 2025 in the Court of Compliance, pursuant to Rule 45, and it remains under consideration. Reasons for the request. Number 1, proper venue under Rule 45. Federal Rule of Civil Procedure 45D3 provides that a motion to quash or modify must be filed in the court for the district where compliance is required. The subpoena, which she issued, at issue lists Las Vegas, Nevada as the place of compliance, and I reside and work there. Courts have repeatedly recognized that only the compliance court has authority to enforce or quash a subpoena in the first instance, absent a transfer under Rule 45F. And then we cite the case law. I'm going to put the word only in italicize. Only the compliance court has authority to enforce or quash a subpoena in the first instance, absent a transfer under Rule 45. Only! The one in Nevada, only! Number 2, avoiding conflicting rulings and promoting judicial economy. Pausing here until Nevada rules will prevent the possibility of two federal courts issuing inconsistent orders on the same subpoena. Federal courts favor coordination between districts to promote judicial economy and avoid the risk of inconsistent judgments. And then we cite the case law. Federal Rule of Civil Procedure 45F and its advisory committee notes emphasize that transfer and coordination between courts is intended to avoid burdens on local non-parties subject to subpoenas and to promote consistent rulings. Thank you, ChatGPT. Additionally, my letter to the judge today says, this coordination concern is especially relevant here because the U.S. District Court for the District of Nevada, where the subpoena's place of compliance lies, has already ordered plaintiff to respond to my motion to quash by today, Monday, August 11th, 2025. That deadline is 2 days before my response to plaintiff's cross motion is due in this court on August 13th. As a result, it is highly likely that the Nevada court will complete briefing and potentially issue a ruling before this court would rule on the cross motion here. Allowing Nevada to proceed first would ensure efficiency, conserve resources, and avoid unnecessary duplication or inconsistent outcomes. If Nevada resolves the matter, further proceedings here may be unnecessary. 3, no prejudice to plaintiff. Plaintiff has already indicated an intent to respond in Nevada. Any necessary proceedings in this court can resume promptly if Nevada declines jurisdiction or transfers the matter under Rule 45F. This request is not intended to delay for delay's sake. I will respond in this court immediately if the Nevada court determines it will not decide the motion to quash or transfers the matter to the Southern District of New York. For these reasons, I respectfully ask the court to extend my August 13th, 2025 response deadline and pause further briefing on plaintiff's cross motion to compel until the Nevada proceedings have concluded. Respectfully submitted, Mario Armando Lavandeira, Jr. I'm going to do a little more groveling. Hold on. You know what? First, I'm going to change the beginning. I'm not going to say dear. I will say most esteemed Judge Lyman. Most esteemed Judge Lyman. And then the end, I will say, I appreciate your Honor's guidance, thoughtful approach, and kindness when responding to me and ruling as I represent myself without a lawyer, pro se. Thank you for your consideration. Respectfully and humbly submitted, Mario Armando Lavandera Jr. So, that all was a big L for me today, but I took a win for others, and I'm really proud of that. The judge just issued another order responding to my letter that I told you about in the video I posted just before this one. Remember how I shared with you all in the video I posted just before this one that Team Kaka has a history of sharing the personal information of non-parties in this litigation? They have repeatedly posted the home addresses of people that are not any of the defendants. They could have filed that under seal and uploaded a redacted version for the public, but they didn't. And they haven't. Repeatedly, consistently, as recently as just this past Friday, August the 8th. On that day, Team Pinocchio filed multiple privilege logs sharing publicly the private phone numbers of multiple non-parties. As with home addresses, Team Delulu could have filed it under seal, redacting the information for the public court docket, but they chose not to. They were inviting harassment and real safety concerns for these non-parties to the lawsuit. And even though neither party, nobody on her side, and none of the lawyers for the Baldoni Wayfarer parties, no one asked for this that was just submitted on Friday to be sealed, but I did. I asked for it. And I sent a letter to the judge, and the judge just ruled on my letter without giving me credit. But we know this is why he did it, because nobody asked him to seal those privilege logs. And he just ordered the following. Lively's lapdog ruled today after the letter that I sent off yesterday. He said, quote, "The clerk of court is respectfully directed to seal public access to docket numbers 5874, 5875, and 5878. Those are the privilege logs with the personal phone numbers of non-parties to this litigation. I am in my L. Woods era, and I am here for it. It's stressful. It's draining. But I'll take this win. I will take this win for others. And hopefully I will still get a win for myself, and the judge will now grant this new, different, very sensible request for an extension and a pause. But he probably won't. This judge is biased, corrupt, crooked, awful. I can say this all in my video. These are my opinions. Okay? These are my opinions based on what I am seeing. How do you think the judge will rule? How do you think he should rule if he wasn't biased, crooked, corrupt, bought, and paid for? Thoughts on my letter asking for a request of time and a pause? Thoughts on the win that I got? Thoughts on her? Thoughts on Baldoni? Thoughts on anything and everything? Let's discuss it all in the comments section. P.S. I almost forgot to say this. In the judge's ruling today, ordering the sealing of the privilege logs with the personal phone numbers of the non-parties to this litigation, the judge did not issue any sanctions, as I asked for in my letter. Not only that, the judge did not even warn either side to file under seal personal, private information of non-parties. He didn't reprimand them because it's Lyman, her lapdog. Corrupt, biased, bought, and paid for. This order to seal would have been a great reminder for all parties. If you are handling home addresses or personal phone numbers, file that under seal. But he didn't say that because... So, yeah, I'm not feeling optimistic about my latest request for extension and pause, but send some good vibes my way. Or at least leave a comment, share this video, help me with engagement, subscribe or follow if you're not doing that, and I will see you in the comment section.